Okay, we are starting right now. Hopefully I'm live. I will check just a couple of moments in time checking the connection to both streaming platforms. I want to remind everyone who is joining us today that we are streaming on both LinkedIn and YouTube. So let me just a couple of more moments. Okay, everything works here. Yeah, nice. Yeah. Okay, I guess we are good to start. Okay, welcome in. So let me introduce myself first. My name is Joanne, and I'm co-founder of the privacy agency MarketLex. We are helping companies, business owners, everyone who actually has any relation to personal data to stay compliant. To stay compliant, first of all, with privacy laws for sure, and to ensure that their privacy operations and their business operations are actually architected in the correct manner, right? In terms of personal data protection, in terms of privacy laws. So this is our main role. I'm a practitioner. I'm a privacy practitioner. I'm also a practicing DPO, meaning the data protection officer, and as I've already mentioned, so I help companies stay in the line with their privacy laws and help them to ensure that everything they do, everything they actually collect from users, from their customers, stay in the line with their latest privacy laws regulations. And today we actually will talk about one of my most this topic I like most of all, because I do a lot of this job in my professional life, and a lot of companies, like especially founders, owners, like the one that launch their product, they come with these requests. It's about privacy policies, about development of privacy policies, about actually terms of use or terms and conditions. And for sure, we will talk about some common mistakes business owners usually tend to make in their professional life when they when they actually launch the business, or where they want to, sometimes they just want to revise their privacy policy to ensure that they are in the line, So today we'll talk about all aspects of privacy policies, right, and other publicly facing documents. So I want to start first of all with their actually the one of the main questions. So what actually, which kind of documents are mandatory, right, like obligatory to have, and what kind of documents you're like nice to have, so they are optional and you don't need them for 100%. So we will break down these two groups, and I will explain every type of document separately. I will break down the purpose of this document. I will explain whether or not you actually, as a business owner, as maybe the founder of some kind of business, you need, right, and which one optional and you don't actually need it. Let me check just for a moment. I guess I have some troubles. Let me, yeah, so, okay. Okay, so, yeah, I just had some technical issues. Sorry for this. I guess we're good to continue. Everything seems to work. Okay. Today we will talk about, first of all, we will talk about the breakdown of actually obligatory documents and nice to have documents. Like just nice to have, I mean that they are not obligatory, they are optional for you, right? In some cases, they might be obligatory, and I will explain what actually, where you need to look for to ensure that, for example, you don't need it, right, in your business operations. So first of all, we need to clarify some of common issues before actually diving deeper in this areas of documents that you might need, right? So I would say that the first question that you as a business owner need to ask here is what actually the type of business you're engaged in. So there is a plenty of different business models. You can operate online, you can operate just on offline. But even if you're presented offline, in most cases you have some digital presence as well. Especially when you have a website, even you have just one landing page. In most cases, you probably will have some kind of web form for customers, potential customers to contact you, or maybe you have some analytics tools actually present on your website, meaning that you are already collecting some personal data online as well. So you know that there's different types of business models and there's for sure different regulations. Some business engaged in highly regulated environment, especially when we talk about healthcare business. If you have any connection to health data, any connection to biometric data, you are in a highly regulated environment, meaning that besides just regular privacy laws like common one, probably another stricter requirements, stricter regulations will apply to your business as well. It doesn't, I mean, you could also be operating, let's say, in e-commerce environment, meaning that you're selling some goods, some products online, right? And for sure, you are engaged in operations with digital money, with digital product. So you will also need to check the regulations that actually that have any connection with this type of business, with this type of relationships, right? So this is the first one aspect that you are actually checking and that we are defining, and we understand what laws we are going to check next, because as I've already said, depending on the nature of your business operations, we for sure need to be clear on what types of regulations, on what types of laws we need actually to look for. So the next question, what actually the form or actually the model of your digital presence? So you might have a website, or you might have mobile app, for example, or maybe you actually have both of this, and this also influence on actually the type of regulation and on the type of your obligations, including towards having the privacy policies, having terms of use, or other documents. We will talk about it a bit later. So if, for example, your business has both of this, like a website and mobile app, let's say, and you have your mobile app launched on Apple Store and Google Play Store, these actually platforms, they do have additional requirements. They do have additional regulations towards the developers of mobile applications. And you for sure need to ensure that when you actually upload your mobile app to these platforms, you are staying compliant and you are submitting these forms. In most cases, these forms relates to personal data protection, because you need to disclose to users, to your potential users, what type of data you are collecting, how you are going to use this data, with whom you are going to share this data, how you will retain this information, and a lot of other aspects. And like both of these platforms, they have their own requirements. And when you actually have, or you're planning to launch mobile app, you need to be aware of these regulations as well. So the next question you need to check for. So what actually the type of activities your users are going to be engaged in? So maybe your users will just be able to browse your website, to check some information, like if you're having just a landing page, for example. Maybe you even don't have any contact form, you don't have any inquiry form on the website, or like I said, you just have some presentation about your product, right? Or maybe you just leave your contact details on the website and users can send an email to you to get some additional information, right? So in this case, you're still collecting some data, even if it's not happening directly on the website, but you are collecting their email, right? And in the email address, when they send actually your email, right, they do clarify some details, maybe even they share some additional information about them, right? And this information can also be regarded as personal data. So you need to be careful about this as well, and need to check actually what actual type of activities your users are engaged in, to be clear on what actual sections, on what actual types of information you need to put in your privacy policies or in other documents, right? Another aspect, which is actually really important to check, are you going to be engaged? Are you going to have any connection with the sensitive information, with the sensitive personal data? As I've already mentioned, health data, typical one type of sensitive data, or like sometimes they are called special categories of data that actually require higher level of protection. Or maybe you are engaged with some types of activities with children, right? And when we talk about children data, we also need to think about special regulation. In the United States, we have a special federal regulation that actually relates to the protection of personal information of kids, right? So, and if your product may be even targeted on this audience, on children, for sure you will need, first of all, check this federal regulation, and only then you are going to check other ones that also probably will apply to your business. And from this point, you are going to understand more clear what types of data, what types of documents, what types of information you need to disclose on your website, and what documents should be present there. So now let's talk about two groups, as I've mentioned before, that you will probably need to have as a website owner, and like good to have or nice to have, right? So when we talk about obligatory documents, first of all, for sure, we talk about privacy policy. And this is like your constitution of your privacy operations that regulates all aspects of protection of personal data from your users, from your website visitors, from your customers. So for different types of data subjects you're actually have relation to. And this document needs to be disclosed to your users publicly. It should contain all basic details, starting from the types of data you're collecting, like the purposes of data you're actually processing this data for, sharing practices, meaning with what type of data subjects you are going to share the information about users, right? You will also need to disclose their rights, their choices that your users have, right, when they engage with your business. You will probably also put their contact details, how the users can contact you, and some other, right? So actually, this is like I've already said, this is like a basic one, and it's for sure will be 100% mandatory for your business if you have just one piece of data collected, correct? Okay, so even if you, as I told you, even if you collecting this data only not directly from your website, or you just put your email address on the website and users still can contact you, right, when they send email address, it also will mean that you are collecting this data because you actually disclose this information to them. So the first one. The second one, it's probably terms of use or terms and conditions, sometimes terms of service. It doesn't matter how you call them. They do all serve the same purpose. They do all have the same meaning, right? So this is a document that explains basically how is your website configured, what actually you're offering. Maybe you're describing there is some services you are offering on the website. Maybe your product has some specifics and you need to disclose this information to your users, because especially when you're in a highly regulated environment, you need to disclose a lot of details about your products, right? You need to disclose some specifics about your products. If you're in the e-commerce business, for example, and you're selling goods online, you also need to disclose information about your return or refund policy, whether you have it or maybe you don't have it, depending on actually regulation, depending on their geography where you are present. There might be different rules towards that. You might think that I don't need to provide this to users, I can just ignore this provisions, but actually it's not true, because you're regulated by the regulations, by laws of different countries, and you need to check to see what actually laws apply to your business to be sure to be able to say whether you actually need this or not, right? So what else terms of use regulate? For sure, they will provide some details about users' rights, about the obligations. Important parts of terms of use also relates to the restrictions, to actually some basic rules that users need to follow when they communicate with you, when they actually engage with your products, with your website, maybe with your mobile app. So for sure they need to understand these requirements, these restrictions. You will also put some basic information about your responsibility as a website developer or as like owner of this business, right? There will be also different provisions on liability, limitation of your liability, probably on the indemnification provisions, etc. Right? So you do see a lot of such documents, and they actually serve the same purpose, but for sure they will have different content, because this content of these policies, of these documents, it's closely relates to the type of business you're engaged in, the type of services or products you're actually offering, right? So you actually will probably one of their mandatory documents that you will probably need also be cookie policy. And when I talk about cookie policy, we speak about the different type of information, of personal information that is collected passively, meaning that users do not provide they do not share some types of information additionally. They do not voluntarily provide this data, right? So when different cookies, when different tracking technologies, pixels, or some marketing tools are placed on the website, everything that helps you to track users' behavior, that will help understand special activities that your users usually engage in. It will help in most cases, help your marketing team to see how you actually good perform, right? So it for sure, it will help you to improve your product, to change something. So that's why you have these tools present on the website. But the cookie policy, it's actually the document that helps your users to understand about this practices more. It helps to break down the types of cookies you're placing on the website. It helps them to get clear picture on how they can manage these preferences. Maybe you even have special cookie banner, special cookie consent tool that help users to figure out and to manage this actually cookies manually. Through this special tool. And depending on your user audience, depending on your presence as a business, like if you're exposed in the European Union, if you are also present in California, and you are subject to the CCPA law, right? For sure, you will need to disclose this information, and for 100%, you will need this document be present there. In some cases, you can combine information on the cookies in your privacy policy and put it as a separate section. It depends. It depends on how many cookies you're actually placing on the website, how many categories of them you have. If it's like really vast majority of cookies placed on your website, I would suggest doing a separate cookie policy and describing all these aspects separately. If it's just like a website that has like limited type of cookies or tracking technologies, you could probably be able to put just a separate section in your privacy policy, and you will be all right. So it depends on the business model and depends on your specific privacy operations on your website. So nothing like I cannot say like 100% how you need to actually act in your particular situation. The second group of documents, which is actually nice to have, or even sometimes maybe you will probably be required to have, but in most cases they are not usual, right? Not usual for absolutely everyone. The first document is data processing agreement. This is actually the document that clarifies your role as it clarifies your role in both actually business roles. You can be a data controller or you can be a data processor. So if, for example, you collect information from your users in different roles, as a data controller, you do have privacy policy, but as a data processor, you will need to have data processing agreement. So this is a type of document that explains how you actually going to use the data of end users, meaning not the users that came to your website directly, but if you have customers or clients and they do actually use your products in such manner that they can additionally upload some personal information about their own clients or their own employees or maybe other individuals, and you as a data processor actually use processes, store this data, like have any connection to this data. In this case, you are not serving as a data controller, you're serving as data processor. And in these cases, you will probably need data processing agreement, right, as an additional document. So it doesn't relate to privacy policy. So another document that a lot of business owners like ask for, and like sometimes they do even like demand this document to be presented separately from terms of use, is disclaimers. So especially when you having some types of services that that are between regulated spheres, and maybe you want to make it clear for your users that you are disclaiming some types of liability, that you're disclaiming some warranties, that they do not need to actually expect this. You are putting additional disclaimers on your website that help protect your business, that help to disclose like the real exposure of the services or products that you are offering. And you are putting it additionally on the website to make it visible to your users, to your customers. But in most cases, you will see disclaimers just as a part of terms of service or terms and conditions. So it will be just together. So that's it, right? So we've already break down two categories of documents, of publicly facing documents that you actually need to have on the website. And now I want also to pay attention to some common mistakes that business owners tend to do when they developing their documents or when they want to revise them. So first of all, it will relate to using some templates from just websites, from you just like browsing internet and just checking and looking for some templates and try them, adapt by yourself without any knowing what actually you need to check for, what actually you need to maybe amend. And you just taking this template, you're putting your details of the company information, like the name of your company, and some contact details changed there, and that's all. It's a really bad practice, especially if you don't involve any privacy specialist to check this policy or maybe to revise it. It's really bad because it will not 100% will not reflect your actual business operations. Another common mistakes that business makes is when they just take their developed privacy policies or terms of use from their competitor websites, and they think that, okay, we are pretty the same, so we just can use it, we can just change some basic details, some information there, and we are good to go. No, it will not work as well, because your privacy operations are different. You have different vendors engaged on your website. Your products probably have some special features that you're actually aware of, and it actually differs from your competitors. And you need to understand that your documents that you place on your website, they should 100% reflect your business operations. They cannot reflect the business operations or privacy operations of your competitors. And you cannot just rely on the drafted policies and be sure that everything is pretty okay and I just need to make some basic changes, some cosmetic changes, and I'm good to go. No, it's not. It's a really bad practice. You will need to audit, first of all, your privacy operations, your website, your product, and to prepare a ready-made checklist to ensure what types of data you need to put in your privacy policy on your terms of services. What else? When we speak about privacy policy and terms of service, we understand that these documents are publicly facing, as I've already mentioned. So meaning that you physically probably will not be able to provide every user, every customer that visit your website a copy and ask them to sign it and to return it back, correct? No, it will not happen. You will need to think about some type of form of how you actually can get consent from your users, from your customers, when we talk about agreeing to this privacy policy. And a lot of websites, a lot of business owners make one common mistake up till today. It's when they just put the links on the footer on the websites. Sometimes they even are not visible, right? And in this way, they just hoping that somehow in some point users will see these policies, and meaning that they do agree on them. So this type of way, or this type of placing these documents, it's called browse wrap, right? Meaning that your users cannot do not need actually to actively agree to your policy. You by default think that they will see it somehow, they will actually agree to them, and like that's all, right? It's really bad practice, especially when we talk about special privacy operations or special purposes of processing of personal data, for marketing, for example, purpose, when you're subscribing your users to your marketing newsletter, or when, for example, you need to again, the same situation with cookies. When you're placing these cookies on your website, and these cookies collect a lot of behavioral data, they also collect device data of users, they collect IP addresses, and this information is regarded as personal data as well, right? And you cannot just passively get this just assume that you have this consent from users. No, especially in highly regulated environment, in the European Union, in California, you need to get active informed consent from your users. What does it mean? So you need to apply some type of form. You can apply additional, you can just actually implement additional checkbox. You can implement additional form which will actively collect users' consent to your policies. Your users need to be aware of the type of business relations they are entering in. They need to be aware of how you're going to use this data, how you, as I've already mentioned, how you're going to share this data, what rights they will have, how they can exercise these rights. All these aspects they need to be aware of. So they need to actively agree to your proposed privacy policy. And to do this, we should use click wrap method, meaning that users need to see these documents before they will accept them. They will need to review them, and they will need to, after this, they will need to put the checkbox, or maybe if you have, there is different type of getting users' consent online, right? It can be maybe you're sending first you are marking, they need to actively mark the checkbox, then you're sending them confirmation email, for example, about the fact that they have already accepted these terms. Maybe you're also sending additional electronic copy to them, to these terms and privacy policies they agreed to. All this aspect, they ensures that your users are aware of these practices, that it's at this point it's their responsibility to check it and to check this privacy policy, to review them before accepting, because in this point they are making this consent voluntary, right? So in this point they cannot say that, oh, I didn't see these terms because they are not visible, I couldn't allocate them, I just didn't have any option to see this document. Now they cannot do this because they already accepted, and this is a good practice, right? When you have this, you will be your terms of service or your privacy policy from this point, they have enforceable action right now. So this is our really, really important points. And the last point I would also like to pay your attention to as a mistake and also as a recommendation. You need to understand that actually the scope of privacy laws apply to your business first, to be sure that the privacy policy that you are developing is really compliant, right? So because if you have, especially when you have different audiences from different countries, you have a lot of users coming from different geographies, right? You need to ensure that you have checked all privacy laws applicable to your business, and you've checked the requirements to privacy policies, to privacy notices that disclose in these privacy laws. Because for European Union users, you will have additional rights that should be guaranteed to European data subjects. In California, you have another scope of users' rights and choices that you need to ensure that they have. And all this aspect you for sure need to check in these privacy laws. By the way, if you want to check, if you want to get some insights on how you can understand what privacy laws apply to your business, you can check our previous webinar where I specifically talked about this topic, and we clarified some basic moments on how you actually can check which privacy laws apply to your business. So that's actually all as of today, guys. And I really hope that I have provided you some basic information, some basic insights on how you actually can start working on your privacy policy, or maybe if you have some plans and you just need to revise your privacy policy now, you will be a bit more aware of this process about